much, Luca. That was very insightful as well. We're now going to listen to Iris Lellouche from the University of Lille in France. And she will be talking about the Spanish legislation, from the Spanish legislation to the French legislation. She will be talking about she will be talking about the transition of the legislation against the Protestants of the north of France towards the end of the 17th century. And
where's the microphone?
Sorry.
Oh.
Sorry.
In the middle of the 17th century, the legislation concerning the Protestant religion was different in France and in the Spanish Netherlands. In France, since the promulgation of the Edict of Nantes by Henri IV in April 1598, the practice of the Protestant religion was allowed in France and the tolerance towards Protestants was introduced. Henri IV tried with this edict to end civil wars between Catholics and Protestants, which devastated the Kingdom of France since the appearance of Protestantism in the 1520s. Until the accession to the throne of Louis XIV in 1661, this edict had always been preserved in the kingdom. But during the reign of Louis XIV, the tolerance towards Protestants was gradually decreased because the king wanted to establish a religious unity in France. At the beginning, Louis XIV decided not to revoke the Edict of Nantes, but to ban anything that wasn't authorized by this edict with several restricting laws. It is possible to classify this legislation into three parts. The first part is legislation that tried to dissimulate the Protestant religion. For example, it was prohibited for Protestants to sing their psalms in public, or it was forbidden to bury a Protestant during the day. The second part is legislation that tried to prevent the spread of Protestantism. Indeed, the legislation encouraged the Protestant to convert to Catholicism. For example, a financial reward was awarded to those who converted. And the legislation also tried to prevent Catholics from converting to Protestantism. For example, it was forbidden for Protestants to try to convince Catholics to convert. And the last part is legislation that limited the practice of Protestantism. For example, the practice of Protestantism was banned in some cities of the kingdom. But despite these restrictions, in the middle of the 17th century, Protestants still had the possibility to practice their religion freely in the Kingdom of France. In the Spanish Netherlands, the practice of Protestantism was forbidden since the promulgation in December of 1609 of the edict entitled Measures Against the Troubles Raised in Defense of the Catholic Religion. This text was introduced after the truce signed in April 1609 between the United Provinces and Spain during the War of 80 Years. This truce allowed the Protestants from the United Provinces to move, trade, and practice their religion in the territories of the Spanish Netherlands. But Protestants from the Spanish Netherlands took this advantage to also practice their religion and try to convert Catholics to Protestantism, while the legislation prohibited it. Thus, the governors of the Spanish Netherlands decided to promulgate the Edict of December 1609. This edict banned the practice of Protestantism for all Protestants in the territories of the Spanish Netherlands under penalty of banishment. In the middle of the 17th century, this edict was still applied. Therefore, in the middle of the 17th century, the practice of Protestantism was allowed in France, but was forbidden in the Spanish Netherlands. At that time, the current northern France was a part of the county of Flanders and a part of the county of Hainaut, which belonged to the Spanish Netherlands, and the Protestants of these regions were subject to its legislation. They couldn't practice their religion. But Throughout the second half of this century, the Kingdom of France gradually conquered this area. This change of sovereignty had two consequences. First, this caused a modification in the judicial system, which led to modification of the legislation applied concerning Protestantism. When territories progressively conquered by France were under the sovereignty of the Spanish Netherlands, the judicial system was simple. In the County of Flanders, the Ghent Council was competent to judge in appeal judgments of inferior court, and the Great Council of Malines was competent to apply the revision procedure to this judgment. And in the County of Hainaut, the Provincial Council of Hainaut was competent to judge in appeal judgments of inferior court, and the Great Council of Malines was competent to apply the revision procedure to these judgments. But the French conquest divided the counties of Flanders and of Hainaut. Some inferior courts became French, while the superior courts remained under the sovereignty of the Spanish Netherlands. It was therefore important to provide a French competent superior court for these conquered territories. And two options were possible: to create a superior court or link these territories to an already established French superior court. The second option was applied after the Treaty of the Pyrenees, which ended the war between France and the Spanish Netherlands in 1659. A few cities of the Hainaut County and 3 cities of the County of Flanders became French. And because of the proximity of jurisdiction, inferior courts of Flanders were attached to the Provincial Council of Artois by an edict of February 1664, and inferior courts of Hainaut were attached to the Parliament of Metz by an edict of November 1661. But the first option, the creation of a superior court, was applied during the Devolution War from 1667 to 1668. Louis XIV conquered a lot of cities of the County of Flanders, and the capitulation of these cities imposed to the king to respect the privileges and peculiarities of the Flemish provinces, and particularly in legal and judicial matters. Or, if the king decided to link the inferior court of Flanders newly conquered to a French superior court already established, it would be impossible for the king to respect the capitulations. Therefore, Louis XIV decided to create a new superior court by the Edict of April 1668. He established a sovereign council in the city of Tournai and not a parliament, because at that time the conquered territories formed a very small jurisdiction. This edict gave the sovereign councils jurisdictions and competencies. Concerning the jurisdiction of the court, the Edict of April 1668 didn't exactly specify it. It just evoked Tournai and Tournai country and the other cities conquered during the war. This can be explained by the fact that this edict was recorded before the signing of the Treaty of Aix-la-Chapelle in May 1668, which ended the Devolution War. Therefore, when the Edict of April was written, the war wasn't over and the new borders were not drawn. However, the Treaty of Aix-la-Chapelle confirmed the conquered territories and the jurisdiction of the sovereign court. The jurisdiction continued to evolve during the first years of its existence. In August 1678, one edict attached to the jurisdiction of the sovereign court the cities of Hainaut, which depended on appeal of the Parliament of Metz in the Treaty of the Pyrenees. And in March 1679, one edict modified the jurisdiction again. Few cities reverted in the jurisdiction of the Spanish Netherlands, and a lot of cities became French. This new border was created after the signing of the Treaty of Nijmegen in 1678, which ended the Dutch War. If the Edict of April 1668 was relatively obscure concerning the jurisdiction of the Sovereign Council, he distinctly established its competencies. Louis XIV gave two competencies to this new court: the ability to judge royal cases and to judge in appeal the decision of inferior courts newly conquered. It was an assignment of competencies entirely conventional for a French superior court. But its competencies were submitted to the application of the capitulation of the Flemish cities, which imposed to respect the privileges and peculiarities. This is why the Edict of April 1668 imposed two conditions. The first condition was that judgment of the Sovereign Court of Tournai had to comply with the legislation of the Spanish Netherlands. It is for this reason that French legislation, which conflicted with legislation of the Spanish Netherlands, wasn't applied in the jurisdiction of the Sovereign Council. The second condition was that the judges of the Sovereign Court of Tournai had to be local judges. In fact, only local judges could really understand and apply the peculiarities of the Flemish provinces. The Sovereign Council appears therefore as a particular court in the Kingdom of France, with a jurisdiction in movement and legislation which need to comply with the legislation of the Spanish Netherlands. Concerning the Protestant religion, we saw earlier that the legislation was different in France and in the Spanish Netherlands. Indeed, when the Sovereign Court of Tournai was established in April 1668, the practice of the Protestant religion was allowed in France, despite some restrictions, and was forbidden in the Spanish Netherlands. The members of the Sovereign Council decided not to apply the Edict of Nantes for three reasons. The correct application of the Edict of April 1668, which imposed that French legislation in conflict with those of the Spanish Netherlands were not applied, or the Edict of Nantes, which allowed the practice of Protestantism, was in conflict with the Edict of December 1609, which forbade it. The second reason is the correct application of the capitulation of the Flemish cities, which imposed to maintain exclusively the Catholic religion in their area. And the last reason is that Louis XIV tried to establish a religious unity in France since the beginning of his reign. Therefore, by not enacting the Edict of Nantes, the Sovereign Council was contributing to the will of the king. If the Edict of Nantes was not applied in the jurisdiction of the Sovereign Council, some of the repressive texts introduced by Louis XIV were enforced, because they didn't conflict with the legislation of the Spanish Netherlands. For example, the Edict of March 1683 prohibited to convert a Catholic to Protestantism, or the Edict of June 1685 that forbade Catholics to marry a Protestant. Nevertheless, from 1668 to 1685, no legislation was taken which forbade the practice of Protestantism, and therefore no legislation provided the penalties. In that case, if a Protestant practiced anyway his religion in the jurisdiction of the Sovereign Council, what decision could judges take? The court made no judgment on this issue. Therefore, it is impossible to know the exact answer to these questions. However, two hypotheses should be examined. The first one is that the judges had the order to apply the legislation of the Spanish Netherlands. Thus, the Edict of December 1609, which imposed to condemn to banishment Protestants who practiced their religion. In that case, the lack of judgment could be explained by the fact that Protestants hadn't practiced their religion, or they hadn't been caught, or there was no Protestant in the jurisdiction. The second hypothesis is that judges did not receive any orders and preferred not to persecute the Protestants who practiced their religion because they didn't know which penalties applied to them. Finally, in October 1685, Louis XIV promulgated an edict which revoked the Edict of Nantes and officially forbade the practice of Protestantism in France under the penalties of galleys for men and confinement for women. The Sovereign Council of Tournai immediately applied this text because it was in conformity with the legislation of the Spanish Netherlands. This is how the Protestants of its jurisdiction were finally judged like French Protestants. Thank you.